Hi there. This is Wage and Hour Law, California Wage and Hour Law 101. There's tons to cover, but I'm not going to cover a good chunk of it. Let's just start with the bare bones basics, starting with you have hired a worker, an employee, all right, and you're a California small business owner. There's only two kinds of employees, and some of you may have heard of these terms of art. We call them exempt employees or non-exempt employees. 99% of your employees are going to be non-exempt. Why is this important? Because when they're non-exempt, what that means is they are not exempt from all of the nitty-gritty California Labor Code provisions that govern payment of wages, rest periods, meal periods, and a whole bunch of other stuff. Okay, and there's special rules that make an employee exempt, and we're not going to go into the details. But I'll say this. One of the rules is that you must pay the worker on a salary basis that's the equivalent of at least twice the California minimum wage, which right now in September 2025 is north of $66,000, I think. You can do the math. Just take $16 an hour times 2, that's 32, times 2080, 2080 hours in a year. And you get the minimum salary that you need to pay the person for them to be exempt. But that's not everything that it takes to make them exempt. So one big misconception for many small business owners in California is that if they pay a worker a salary, $40,000 a year, which is less than the minimum required, that automatically makes the person exempt. And it absolutely does not. For two reasons. One, if you pay them only $40,000, you haven't met what we call the salary basis test, which is $32 an hour times 2080 hours in a year. But even if you did, let's say you paid the person $80,000 north of the minimum salary required, that's just one of two tests. There's a second test, which I call the duties test, and it's got a bunch of subtests to it. But basically what it says is you have to be performing certain kinds of exempt duties 50% of the time for the person to be exempt. And like I said, I'm not going to go into the details, but just think of a CEO of a 50 employee company, right? Probably the owner, but if it wasn't the owner, let's say the owner is off traveling the world, playing golf every day or whatever, and has established a successful enough small business where they can hire a CEO at $150,000 a year or something to run their small business. That person is likely executive exempt, we call it. They're managing at least two people, getting paid a salary that's north of the minimum salary required. And essentially they're just managing all day long, which is an exempt duty. So it's well more than 50% of their day. They're running the business, doing strategy, hiring, firing, all that stuff. So they're going to be exempt. Now that's all I'm going to talk about with respect to exempt employees for today. Key takeaway, just because you pay a salary does not make them exempt. And exempt from what? Exempt from overtime, for example, right? So it's probably a good place to start there. If you've got a non-exempt employee, you have to pay them overtime, right? And the California overtime rules are quite onerous. Anything over 24-hour work day up to 12 hours is overtime. Anything over 12 hours up to 24 hours in that same work day is double time. Anything over 40 hours in a work week is overtime. And you have to run the calculations both ways, daily and weekly, and pay the greater overtime number, of course. Lastly, there's a quirky rule that says, which is very unusual, but it does happen. If somebody works 7 days in a row in the same work week, let's say your work week is Monday through Sunday, 7 days in a row, and that person works all 7 days in that work week, Monday through Sunday. Then on Sunday, that seventh day worked in the work week, the first 8 hours, up to the first 8 hours is overtime already. Even if they only work 4 hours, it's going to be overtime on that seventh day worked in the work week. Anything over 8 is going to be double time. So that's a tricky rule, very unusual, but something to keep in the back of your mind. Just don't make people work 7 days in a row if you can help it. So that's a key one, right? I mean, one of the big problems is if somebody is, quote, misclassified, somebody is exempt when they should have been non-exempt, and this misclassified person alleges they work a ton of overtime, 3-4 hours every day, 15 hours a work week or whatever, it becomes a big number because the salary does not cover overtime. It only covers 8 hours in a work day. So anything over that's overtime or double time, you have to calculate the regular rate of pay, which is take the salary divided by 2080 hours in a work year. You get an hourly rate, which is known as the regular rate. And then you have to pay 1.5 times that regular rate for every single overtime hour and 2x that regular rate for every single double time hour. So it's the worst case scenario in terms of an overtime claim issue. And we see this all the time, misclassification of exempt status, and it results in an overtime issue. All right, now focusing on non-exempt, or continuing to focus on non-exempt, what other labor code sections are they not exempt from? Okay, two key ones, rest periods and meal periods. Now this gets real silly in my mind, but it's not funny. It's not a laughing matter because it is very common. I see that in multiple times in a day, I get calls on wage and hour law, and it's very stock or automatic that if there's a wage and hour case filed, complaint, it's going to have a rest period claim in it, and it's going to have a meal period claim in it. And so it's no laughing matter because, like I tell my small business owners, once you've been sued, you've already lost, unfortunately. Why? Because you have to spend your hard-earned money on lawyers like me or some other law firm to defend you when you'd rather be spending your hard-earned money on other things like running your business. It's going to take up your time and your emotional capital. But even worse, in most employment type claims, and certainly wage and hour claims like minimum wage, overtime, rest period, and meal period claims, if that employee, and hopefully it's a former employee, gets anything, their attorneys automatically get their fees, 100% of them. So they might get only $5,000 in a rest or meal period claim or whatever the wage claims are, but then the attorney's fees can be hundreds of thousands of dollars, well over 100,000 easy. 250,000 would not be out of the question if the lawsuit is litigated for any length of time, or if it's kind of like even moderately litigated. It can become very expensive. And meanwhile, you're paying your own lawyers. That's why you've already lost. Even if you win outright, they get nothing. You still have to pay your lawyers, spent your time and wasted your emotional capital. But anyway, so getting back to how we avoid lawsuits in the first place, right, which is the point of these sort of one-on-one videos, is if you know the law, then you can follow it, hopefully, and avoid getting sued. And so rest periods and meal periods. So the law is for non-exempt employees, employers must authorize and permit a 10-minute paid rest period for every 4 hours worked or major fraction thereof. Major fraction is 2 hours plus. Right. So, and by the way, if they work 3.5 hours or less, then there is no rest period, no rest period need be authorized or permitted. But what that means is if they work 3.5 to 6 hours, right, 4 plus a major fraction thereof, they're entitled to 1 10-minute, and it's paid rest period. But they're free to, they're relieved of all duty, free to leave the premises, free to do whatever they want to do during this 10 minutes of paid rest time. If they work more than 6, up to 10 hours, which is going to be your average kind of office work environment, between 6 and 10, i.e. 8 hours, then they're entitled to second 10-minute paid rest period, relieved of all duty. Those are the rest period rules. I'm going to talk about the meal period rules now and talk about what documentation you need to have in place in order to protect yourself, your small business, from these sort of crazy lawsuits. And they're dime a dozen, unfortunately, in the sunny state of California. So meal periods. Meal period rule is different, but the concept is kind of similar. They must be relieved of all duty during a meal period. Meal period must be a minimum of 30 minutes. Meal periods are unpaid, though, unlike rest periods, which are paid. Meal periods are supposed to start no later than the 5-hour mark into a shift. They clock out for the meal period, free to leave the premises, relieved of all duty, same as for rest periods. And the biggest difference is it's more time, it's unpaid time, and the timing of when the meal period is supposed to start, no later than the 5-hour mark. Okay, So how do we, there's a case called Brinker that sets forth these rules. It's a California Supreme Court case. Big restaurant group had to litigate this. I'm sure millions of dollars are spent on the defense to create, what eventually became the rest of the meal period rules in California. And so what does Brinker say? Brinker says, as long as we authorize and permit rest periods and we provide a minimum 30-minute off-duty unpaid meal period, then essentially, thankfully, employers in California are adults and they are responsible for taking their rest periods, right? And responsible for taking their 30-minute meal periods. So what does it mean? What do we have to do, though, in order to authorize and permit rest periods and provide meal periods? You need to have a written policy. Okay? Can't overemphasize that. Must have a written policy. Should be in your employee handbook, which you also should have. I won't call it a must-have, but any employer in California, even with one employee, these days needs to have an employee handbook, which is going to contain your timekeeping policies, rest and meal period policies. So there should be 4 key policies in your handbook. One is a timekeeping policy. Timekeeping policy in writing that says you shall record all of your actual hours work, no more, no less. Working off the clock is prohibited in writing. So you're telling your non-exempt employees they're responsible for keeping track of every second they work. And hopefully it's by an electronic timekeeping system these days with biometrics or a card swipe or some very easy way for them to punch in and out. Because that's rule number 1, punch for all hours work. 2, rest periods. Before I get there, I'm also just getting into meal periods because they need to clock out for the meal period, as I just said, right? So you need to make it easy for them to clock out, start of the workday, clock out for the meal period no later than the 5-hour mark, clock back in no earlier than 30 minutes, not 28 minutes, not 27 minutes, at least 30 minutes later, 31 minutes is okay, and then they clock out for the day. So like I tell all my employer clients, when you've got non-exempt employees for a typical 8-hour shift, I expect to see 4 punches. In for the day, out for the meal period, back from the meal period, and out for the day, right? 4 punches. And we need to audit the timesheet. No, I'm getting ahead of myself. Back to the employee handbook. Rest period policy in writing. I already said the rule. You're going to state that in writing. And what you're also going to say is that if any manager, supervisor interferes, dissuades, prevents you from taking your 10-minute paid rest period, you are to notify the CEO immediately, the owner immediately, whoever the highest ranking person is immediately, HR immediately, because we need to do something about that as employers if that's happening. Because if we are not authorizing and permitting rest periods, we have a 1-hour pay penalty for every day that occurs. Okay, so if you're paying somebody $25 an hour and they don't get a rest period, that's $25 extra that you should be paying them. Meal period policy in writing. We went over the rules, same idea. You're going to put it in writing, the rules in writing, but you're also going to tell them same thing. If anybody's interfering, dissuading you, preventing you from having your 30-minute off-duty meal period, notify the CEO immediately. That's the 3rd policy in your handbook relating to timekeeping and wage and hour stuff. 4th one is an overtime policy, and we talked about the overtime rules. You're going to put in the daily overtime rules, the weekly overtime rules, and that quirky 7-day days worked in a row rule. And, we also mentioned federal law, the FLSA, Fair Labor Standards Act, but in California, it doesn't really matter because there's only one overtime rule under federal law, and that is anything over 40 hours in a work week is overtime. Well, we have that rule in California too, but we have all the daily overtime requirements. So we don't really concern ourselves with federal law when we're talking about complying with wage rules in California. All right, so what next, right? So we know the rules, okay? We have written policies that cover the rules. Oh, by the way, we have employees, when they're onboarded or anytime we roll out a new handbook, all employees sign for the handbook so that we can prove they received the rules, they know the rules, they understand the rules, they agree to follow the rules. And therefore, under Brinker, the California Supreme Court case, we have essentially authorized and permitted rest periods and provided meal periods. They know about them. So now it's on them as adults to take them, right? As long as we've done nothing to prevent them from taking both of those things, there is no penalty. All right. So that's kind of fundamental starting blocks. Then I mentioned time records. You are responsible for accurate timekeeping, but you as the employer are delegating that to your non-exempt employee. And so what we need to do on a regular basis is audit time records, right? Because we should be able to see the 4 punches I mentioned for every day they work. And you definitely want to audit them periodically to detect when people are doing things like missing punches, like forgetting to clock out for the meal period, or they're clocking out late for the meal period. They clock out at 5.5 hours into the shift. That's late. They should have clocked out before the 5-hour mark. They clock short meal periods, 28 minutes. And if you're thinking this is a lot of work, it is, but it's well worth it to avoid being in a world of hurt if you get sued on a class action basis. Say you've got 20 employees and get sued by one of them, representing all the rest of the 19, and also under the Private Attorney General Act, PAGA for short, where one aggrieved employee can sue on behalf of all the other allegedly aggrieved employees in your workforce. And this, by the way, is whether these coworkers want to be dragged into a class action or a PAGA case or not. They have no choice. All it takes is one to sue you on a class action or a PAGA basis or both. And this is a very serious lawsuit to defend. Now, if you have everything perfect, and it never is, but if you're making a good faith attempt to be perfect and you're auditing your handbook policies, you're auditing time records every payroll cycle, and maybe not even auditing, just looking at the time records, every one, having somebody, that's their dedicated job, because it's that critical. If we have errors that are showing up on the time cards, the time records, then we're going to have itemized pay stub violations as well. We needed to have paid a rest period penalty or a meal period penalty. Believe it or not, that needs to be itemized out on the pay stub. So it's kind of like we have to self-police if we did violate the law with rest periods or meal periods. We need to show that on the pay stub and pay them that extra wage rate, which is actually a penalty, but we have to pay that. If we don't and we get sued, then it's fodder for plaintiff's counsel to show that there have been violations of law, including itemized pay stub violations, and therefore this is a bona fide class action, because if it's wrong for one, then of course it's wrong for everybody else, and a bona fide PAGA, Private Attorney General Act case, representative action. So that there's plenty more to talk about with respect to wage and hour law, but I promise you, if you follow this video to the T, although, this is not legal advice. This is, of course, I got to give the legal disclaimer. I'm an attorney. It's just informational to help small business owners out there. But if you follow this advice, then I think you're like a long ways to, one, not getting sued, which is the whole point. Or if you do get sued, then you've been put in the best possible position to shut the lawsuit down as soon as possible with the least overall cost, which is always our goal for you if we end up being your litigation lawyers. Okay, that's it for today. Wage and Hour 101. Well, hi there, Scott Shibayama here. This is an addendum to the video you just watched. And it's time for me to eat a lot of crow because when I recorded these videos, or the video in 2025, I made reference to the California statewide minimum wage being $16 an hour. That's wrong. It was and is, as of January 1, 2025, $16.50 an hour, $16.50. So to the extent I made any reference to the California state minimum wage on this video at $16 an hour, you need to replace that number with $16.50 an hour. And any mathematical calculations that I use based on the minimum wage, for example, the salary basis test for exempt status being a requirement of a salary that's the equivalent of at least twice the California minimum wage. Instead of 16 times 2, you need to use 1650 times 2. So $33 times 2080 in a standard California work year. And whatever that number comes out to be, that's the minimum salary to satisfy the salary basis test under California law. And while I'm on the topic, I didn't mention this, and I'm sure all of you employers to whom this applies already know, but for certain healthcare employers and certain restaurant employers, namely fast food employers, larger ones, the minimum wage is much higher than $16.50. And of course, there may be a city or county minimum wage that you need to be cognizant of as well. So once again, my apologies for the error on the video. It's $16.50, California minimum wage in 2025, not $16. Aloha.